Good evening, this is John Milburn for Laws 12063. This is Advanced Statutory Interpretation and Drafting. We're into week 10, and tonight we're going to start by continuing our discussion around some of the Commonwealth Office of the Parliamentary Council precedents and templates, starting with that which relates to delegation, which is, of course, a highly relevant topic for you. I'll share the screen. You've probably looked at this already. If you've done some research around the OPC website. So an excellent precedent, you'll see there the accompanying notes. Now this precedent, which requires you in practice to complete information in the yellow boxes, as it were, is to be used to prepare delegated provisions at a Commonwealth level. So use this if an act or an instrument provides a power to delegate a power, duty or function, power, function or duty, to use the wording that they've got in paragraph 1. And a power, function or duty may be delegated only if there's specific power in an act or an instrument providing a power to delegate. So of course it's important that you check the delegation provision in the act or the instrument to ensure that the language matches exactly the language in the act or the instrument. So if the delegation provision in the Act provides for powers, functions and duties to be delegated, then the instrument should use the same form of words instead of merely powers and functions. So the precedent is all set up, ready to go, even with notes as to where to include footers and headers, as it were. So it's very interactive. Now, a delegation is not generally given to particular persons. And when you're drafting a delegation, such as per this precedent, you would normally do so in one of two general ways. The first is that it would be to individuals holding a particular office or position. So the delegation then refers to the person occupying or performing the duties of a title, whatever that title might be. The second way that the delegation might be given is to a particular class, for example, SES employees or acting SES employees, usually in the relevant government department. So that's normally the way it goes. When you're looking at this precedent, pay particular note to parts 3.1 and 3.2. So 3.1 provides for the instrument of delegation, and you'll see there that the text should be inserted if delegating powers, functions and duties. And you'll see that it's highlighted in yellow. The yellow highlighting should be removed. So that's the precedent 3.1, and 3.2 goes on to provide for other information in relation to revocation and delegation. So specific precedents there. The next thing to bring to your attention are the word notes. Now these can be a little tricky to find, so I'll just show you how to find them. So again, we're in the OPC web page. If you go to drafting resources, or if we just click on drafting resources, it will take us through to 6 tiles. Well, it should. So they're the 6 tiles. You're probably familiar with those by now. But you'll see that there's no reference to word notes. Word notes are actually the 7th tile, which are not there. But if you go to the drop down, you'll see the 6 that are already shown with the links, and then the 7th is word notes. So if you click on that to word notes, it's basically a series of notes providing information about drafting, and you'll see that they do refer to legislation templates and styles and examples and formatting rules. So for example, if you're dealing with something that relates to tables in your legislation, then go to word note 3.4, dealing with tables. 3.6 deals with formulas, etc. So they're all potentially very useful as precedents. But let's have a look at one of them in particular, which is 4.2, formatting rules for legislation. Now, I won't open it up, but you can download that, as you can all of the others, in either PDF or Word or both. And 4.2, the formatting rules for legislation. Let's see, actually, I probably do have this. I've got a lot of web pages up on the screen. I'll share the screen for that one. Sorry, I'm not sure how to move from one document efficiently to another, so we're getting there. So now, hopefully, you can see the WordNote 4.2, which does provide for the formatting rules for legislation or other instruments drafted in the Office of the Parliamentary Counsel. These are updated regularly, so this one was updated in July 2018, and it provides guidelines about formatting things like cover pages, references to legislation names, headings, layout of forms, tables, etc. So again, some very useful information for you there about formatting. If you have any questions as we go, please let me know. Yes,
yeah.
Thanks,
John,
Nicole.
is that relevant to Queensland and Commonwealth legislation or just
No, this is specifically Commonwealth, and this is where all the best resources are. You can adapt them for Queensland purposes, but these only specifically relate directly to Commonwealth. I hope that answers your question, Nicole.
Thank you.
Thank you. All right, a few times in the past, I've referred you to the drafting manual, and the drafting manual, Commonwealth, in its latest offering is 3.2 2019. We'll see if we can call that up on the screen. I suspect that you've probably bookmarked this one and have it ready to go. So OPC Drafting Manual, edition 3.2, July 2019. Some material there that is very useful in general terms. And when you're using the drafting manual, you'll see that it provides information about the format of legislation generally. And there you'll see that there, format of legislation 6. Bills, titles, instruments, names, commencement provisions, conventions for numbering and lettering, use of Macquarie Dictionary, the style manual, gender neutral information and language, exercise of powers, statutory authorities and other administrative bodies, etc. So also for the purpose of this week's topic, see attachment A, which relates to components of bills and instruments. And I think from memory, that's page 31. So we'll just go through to page 31. And you'll see there, no, not quite. Attachment A. My apologies, I can't find it. But there it is, components of bills and instruments. So description of the division, section, numbering system. So particularly in a Commonwealth level, it gets very confusing. And even though it says that it's designed in a way to avoid really quite obscure numbering provisions, like the example there, 159F, ZZZZG, it does actually become quite tedious looking at some pieces of Commonwealth legislation. So components of bills and the use of division numbering sections is potentially quite useful. The next thing is drafting directions, and again through the OPC you'll see various drafting directions that might assist, and this is one that I'll bring to your attention. We'll have a look at the overall mock-up of drafting directions and the way in which they fit together. So you'll see there a screenshot of the drafting directions, or at least most of them. And the important ones may become obvious to you. I'll see if I can make that a bit bigger. I can't really. For example, the long and short title of bills, 1.1. 1.3 commencement provisions, 1.5 definitions is also important. Number 1.7 lettering and numbering, etc. So initially you'd be interested in the presentation and form of legislation, but then it flows on to issues around usage, content, and procedural matters. So again, you can download each of these in PDF or in Word versions. Let's have a look at a couple of these. I've selected 1.3 commencement provisions and 1.5 drafting provisions. I'll stop the share so that I can find those once again. And we'll start with 1.3. You should be able to find these easily for yourself if you're looking for those. And we'll go to this now. Parliamentary Council drafting provisions, commencement provisions, this is 1.3. And in relation to bills, instruments, commencement provisions, we have detailed information. Now, where it becomes interesting is the attachments which provide for examples. So essentially what this drafting direction does is sets out the way in which commencement provisions are to be drafted, hence the name. And draftment clauses are drafted in table format. The commencement of each provision in the order appears in the draft. There is some information here about retrospectivity. So you'll see there at page 5. And from time to time, various authorities have expressed concern about the use of retrospective legislation. If you're dealing with retrospective legislation in any material that you draft, please look at Section 12 of the Legislation Act 2003, and you'll see that subsection 3 of subsection 12, of section 12 rather, allows for retrospective commencement of legislative instruments, but take note of subsection 12.2, which provides that the legislative instrument does not apply in relation to a person in certain circumstances, essentially in circumstances where that person might be adversely affected and disadvantaged. So if you're involving yourself in retrospective legislation, just be very careful. The other one that you might consider in this series is 1.5, and that deals with drafting directions. Again, I'll share the screen and you should now see drafting directions 1.5, updated in May 2019. So this particular drafting direction deals with the form of definitions. From a drafting perspective, definitions are always a useful tool. Why? Well, simply because legislation tends to be easier to read if the reader can find where a particular expression is defined. And this is really important, can be confident that an expression has the same meaning throughout the legislation. So, what's the lesson for you when you're drafting definitions? As the drafter, there are a few things that you need to do. The first is ensure that there is a general definition section with all expressions defined in the legislation. Now that's subject to a few things, and we'll just go to paragraphs. 14 to 17. Well, no, we won't. That was last year's. So my apologies. So what you need to do is ensure that the general definition is made subject to those things that are referred to in this material. The second is obviously avoid different meanings in different provisions of the same legislation, and avoid defining in one provision of legislation an expression that's used in its ordinary meaning elsewhere. In other words, the consistency of approach is very important. So you may use an acronym that is specific to particular legislation. So for example, GST, it's commonly used, understood. So feel free to use those very common terms where it's appropriate. But be careful for your assignment work. Don't be tempted to put in, those things that are really shorthand in, for example, internet usage rather than legal usage. But I'm sure you understand that. All right, well, we might leave that topic and move on to Chapter 15 of ODGAS, which is an online resource. It's the prescribed reading for week 10. And I hope you've had a chance to look at this. So it is something that is extensive, and it's available to read both online and to download. So in Chapter 15, ODGA's Australian Senate Practice, which is currently in its 14th edition, deals with a number of issues, but in particular, the Senate Practice deals with a number of issues, but Chapter 15 deals specifically with delegated legislation. So again, I'll just share the screen and we'll have a look at that. So I'll share the screen to show you the web page first. So hopefully, no, I'm not sure you can see that. It hasn't come up on my screen, which it does. This happens from time to time. So I'll stop the share and I'll attempt to find the version that I've downloaded. And, oh, okay, so it was there, but it was just smaller, right? Thank you. So I'll just share the screen now for this other version that looks a bit bigger. All right, so this is the PDF version of the same document, the 14th edition, 2016. It's a bit scary because you'll see it runs to over 1,000 pages. So we don't want you to read all of this, but Chapter 15 deals with drafting delegated legislation. So in order to understand how to draft delegated legislation, I guess the first thing we need to do is consider the distinction between primary and delegated legislation. And when you're drafting delegated legislation, you need to refer to the grant of power. In other words, it's not a parliament that is providing this document. It's something which is provided to an authority, a department, a member of the executive under delegation from Parliament through legislation. Now, there are extrinsic materials that typically accompany delegated legislation, and you'll find much of the materials that you need on the Federal Register of Legislation or legislative instruments. So the basic rule is that Parliament is the only body in our system of government that can create acts. But Parliament may delegate some of its lawmaking responsibility to public servants, and hence delegated legislation. So the lawmaking power still belongs to Parliament. It's just that it's delegated it to the public service departments. So there are a couple of key issues here that you need to consider, and this is referred to in ODGAS as well. The first is that public servants can only make statutes if Parliament has expressly delegated the power to do so. the public service may not, under any circumstances, make laws beyond the bounds of their delegation. The second is that generally delegated legislation must be placed before each House of Parliament at a Commonwealth level, and the Parliament may disallow the legislation. What that means is that when Parliament is not actually involved in making the law, Parliament retains a level of oversight to the point where it can say, we have authorised you essentially to create delegated legislation, but you've got to run it by us, and if we're not happy with it, we will cancel it, we'll disallow it, and therefore it doesn't become legally binding. So they're the two basic rules inherent in the creation and observation of delegated legislation. But once delegated legislation becomes law, it's just as much binding on citizens as laws made directly by Parliament. So there are a few rules that relate to the drafting of delegated legislation. There are a few unique considerations. And of course, there are many types of delegated legislation. And the most important, the most common, the one that we think of most readily is regulations. So that's where we mostly will focus on drafting of regulations. But the same process applies in general terms to other forms of delegated legislation. So the prescribed reading for this week, Odger's Senate Practice, Chapter 15, which is on the screen. The Legislation Act 2003, Commonwealth, and some of the other material, for example, Drafting Direction 3.8 from the OPC website. We've just dealt with that tonight, dealing with subordinate legislation, and an excellent article by Stephen Argument, the Legislative Instruments Act 2004, is part of the prescribed reading. So in your study guide, we've got notes about the key terms, what is delegated legislation, what we mean by disallowance, explanatory statement. So an explanatory statement is tabled in Parliament to explain various aspects of the piece of delegated legislation. It's like an explanatory memorandum for principal legislation, but it's not, for example, like a bill. We do have extrinsic materials that will apply for delegated legislation, which is any material outside the statute. And then, of course, you'll see reference to the grant of power, which is the content of the delegation by Parliament. In other words, it sets out what may be delegated, what power does the public service have, and delegated legislation that goes beyond the grant of power is invalid, and the Latin term that we use is ultra vires. Ultra vires means outside or above powers, and therefore it's invalid. So the key is to sometimes think about what it is that's actually delegated. Now, if you're, for example, asked to advise someone in relation to a transgression that's alleged against them, the first thing to do is consider whether we're talking about a transgression that is a breach of statute or is a breach of delegated legislation, for example, regulation. If it's a statute, I guess the overriding consideration is always, has the statute been passed consistent with the constitutional power of Parliament to make such a statute? But when we're talking about delegated legislation, the emphasis is really on whether the public servants that created that piece of delegated legislation have the power to do so, or have they gone beyond their power? So a good case that highlights this issue is Gold Coast Bylaws, and it is 1994 1 QDR 130. I'll just share that case now. And this was interesting in the sense that the Queensland Supreme Court had to consider a bylaw, which is a piece of delegated legislation, like a regulation. It was made under the Gold Coast City Council, and the Gold Coast City Council made this bylaw and said, the selling of goods or the conduct of any commercial activity on a road, on land adjoining a road, or on land under control of the council without a permit is prohibited. So the bylaw made a power, purported to be made under power granted to it under the Local Government Act of 1928. And the Local Government Act gave the council the ability to make bylaws, and I quote, in its opinion necessary or conducive to the good rule and government of the area and the well-being of its inhabitants. So very broad. But the question is, did the bylaw extend beyond the ambit provided by the Local Government Act? And the court found that it did. Justice Thomas, in this decision, said the coverage of this bylaw is astonishingly wide. The activities permitted without a permit would include the carriage of goods, the driving of taxis, the conducting of shops, all banking business, and all obvious forms of commerce, including those conducted by telephone. It's too easy sometimes to fall into a trap, and the trap is to think, well, it's in the bylaw, it's in the regulation, surely the people that created this must have done so lawfully, but we're all human. So, and bear in mind that a lot of things are politically driven. So someone decides that it would be a good idea to create some law, and without necessarily fully understanding the link between the power to make bylaws and the delegated power conferred upon the council goes and makes a law. So the first step always is check whether the bylaw is in fact made pursuant to the appropriate grant of power. So there are 3 steps in this process. The first is to decide, now this is relevant when you're drafting material, which is delegated legislation, but it's also relevant if you're trying to attack something which is being done under that purported power under the delegated legislation. So 3 steps. Number 1, what is the purpose of the grant of power? So again, we're sort of going back to the purposive test there, aren't we? So even if the grant of power is phrased to be quite broad, the courts will interpret it in connection with the underlying purpose of the legislation. And the delegated legislation, if it drifts away from that purpose, is more likely to be ultra vires and struck down. So, for example, the Community Service Aborigines Act 1984 was intended to allow for self-government of Aboriginal communities. And it included a regulation to say that the Governing Council may make regulations not inconsistent with the Act in relation to all matters and things for which it's necessary or convenient to provide for the proper administration of the Act or for achieving the objects and purposes of the Act. So that's very broad, isn't it? So when you're drafting material, just be very conscious of that in not being too broad. So let's go back to that example of the Aboriginal community having this very broad power conferred upon the Governor in Council. So let's assume for a moment the Governor, on the advice of a public service department, used the regulation making power to unilaterally declare full Aboriginal land rights, equating to freehold land over all areas claimed by Aboriginal councils as traditional land. Would such a regulation be necessary or convenient? Well, yes, it would be probably convenient. Giving Aboriginal communities control over massive areas of Queensland would almost certainly assist their welfare if we're looking at it from that perspective. But the question then is, would such a regulation be valid? And almost certainly not, because it purports to go far beyond the purposes of the Act, and certainly not to generate new land rights regimes beyond that is provided by the Commonwealth native title legislation. So don't fall into the trap of drafting something that is overly broad. So number 1, in the 3-step process, what is the purpose of the grant of power? Number 2, what are the limits on the grant of power? In some cases, legislation will prescribe specific limits, and any regulation that goes beyond that limit will be invalid. Number 3 is, are any preconditions required to be met? For example, the Act might say there's a precondition in order for the regulations to come into effect. There must be a declaration, for example, a declaration as to the existence of a disaster. So they're the 3 steps that we need to consider when determining whether the delegation is truly within or outside of the grant of power. Number 1, what is the purpose of the grant of power? Number 2, what are the limits on that grant of power? And number 3, are there any preconditions required to be met? So when you're drafting regulations, follow the established process, have a look at that which has already been drafted. Always refer to the principal provision. In other words, if your delegated legislation is created as a result of power in a particular act, then do refer to that act. The regulation is meant to be practical in nature, so focus on practicality and ensure that the regulation remains within power. All right, so the next source of information is the Legislation Act 2003, and in that regard, there's a few sections that I'd ask you to look at. Have a look at, and if you've got this on your screen, you can follow along now. I won't share the screen for this one. If you're watching this as a recorded session, have a look at the legislation. That is the Legislation Act 2003 Commonwealth. Section 8 defines a legislative instrument. That is an instrument that is of legislative character and is made in the exercise of the power delegated by Parliament. Sections 15A through to 15E establish the Federal Register of Legislation. So the Federal Register of Legislation just didn't spring into being of its own volition or because a public servant thought it might be a good idea. It has statutory force. So the authority which we all understand the Federal Register of Legislation to have comes about as a result of power conferred upon it under the Legislation Act 2003, or conferred upon the OPC under the Federal Register of Legislation. Section 15H requires that all legislative instruments be registered and provides that no legislative instrument will be enforceable unless it's registered. So it's 15H and 15K respectively. The Act requires the provision of an explanatory statement to accompany each instrument, not an explanatory memorandum, but an explanatory statement. It's 15J, and the Act encourages rulemakers to undertake appropriate consultation and report about that on the explanatory statement, which is 15J and 17. All right, I mentioned also Stephen Argument's article. I'll just share the screen briefly. You have this in your reading, so I suspect that you've looked at this. If not, please do so. I'll just highlight a couple of important points. The introduction provides an outline of what this is all to do with, and it applies to instruments of a legislative character. The part that deals with definitions and the significance of that is also important and provides a critique that you might want to consider as well. So why is the definition significant is the part that I'm referring to now. All right, well, I'll stop the share there. Thank you for your patience. We'll continue. So I mentioned that the key reading for this week is Odger's Senate Practice. And Chapter 15 is the important part. To get an idea of how this all fits together, what I'm will refer you to now is, and I'll share the screen for this, refer you to page 439. Now this is which is page 474. Well, it's supposed to be. No, 439. There we go. So it's page 439 of the text, but to get to it through the hyperlink, you need to put in page 474 of 1021. So we have on the screen here figure 1, which is described as scrutiny of delegated legislation. I hope that's not too small on your screen. You'll see the flow chart, which provides for the statute conferring power to make legislative instruments and the scrutiny that's undertaken at various levels, culminating in the creation of the delegated legislation. Oh, this is a tricky little website. It jumps around a bit. Well, at least it does for me. Sorry. So that's the figure that we were referring to there. And finally, the Senate disallowing or the matter going further. All right, so when it comes to the making of delegated legislation, the procedures are, of course, different to those procedures that are used in the enactment of statutes. So there are no stages for legislative passage, there's no bill as per se, there's no opportunity for amendment. But Parliament does get to see this, as you would have seen from the flowchart, and the Parliament, in this case, because we're dealing with Senate, the Senate has the ability to disallow, but the Parliament does as well. So when you're considering this, do have a look at the drafting direction 3.8 that I referred to earlier tonight, which does contain some useful information about the power to make subordinate legislation and some information about the Legislation Act. I mentioned that under the Legislation Act, the Federal Register of Legislation has been created, and I'm sure you're all familiar with that. I'll just share the screen. Well, in fact, I'm sure you all know that, so I don't have to share the screen. Look, so just some tips here. And this will be it for tonight, so an early close for tonight. I hope everything's going well with your final assessment. I'm sure it is. So by now in week 10, 2 weeks out, we should be just about, we should be well into it and have a lot of material there. One thing you can do is try to refer it back to existing precedents. Have a look at second reading speeches, explanatory memorandum, and all of this will help you to come up with some material. If you're looking at drafting, if the drafting involved is of an amendment to an act, then there would be a bill to go with it as well. So, for example, some second reading speeches. Here's one such example. Record of proceedings in relation to the police powers. This is Queensland. Responsibilities are the Legislation Amendment Bill and another example, the Queensland Competition Authority Amendment Bill 2018. All right, so I'll stop the share there. Thank you again for your patience for tonight. Next week, we'll be moving on to a completely different topic. We'll be dealing with correspondence and affidavits. So that will leave you free, as it were, to conclude the assessable part of the material that we're going to cover as your assessment. So weeks 11 and 12, strictly not assessable, but please do join me and do consider the content, because from a practical perspective, it's very useful and important. Any questions before I wrap up for this evening? All good? Okay. All right, well, thank you for your patience, and we'll wrap it up for this evening, and we'll see you next week. All the best then. Bye.